If, as I hope, you've started to become familiar with the SRA's sample question bank for SQE1, you'll have noticed that some questions are just a couple of line scenario and then the 5 options, but others have several paragraphs, like you can see on the screen now, before you even get to the options. So let's see how I get on with one of the longer questions and see whether I can get it done in the average time it takes to answer any MCQ, which is 1 minute 42 seconds, as we all know, but only after the jingle.
If you wanna be solicitors, why don't you come and visit us at SQETV?
I'm going to try and do this MCQ as quickly as I can. I can see it's got quite a long scenario, so let's see how I get on. 3, 2, 1, go. 3 years ago, a woman bought the freehold of a building which is subject to a lease of the whole building protected by the Landlord Tenants Act 1954. Right, so tenant's got security of tenure. Tenant runs a recruitment business from the building. Right, the tenant's in occupation. The term of the lease is for 12 years and there are 10 months of the term remaining. So tenant's in the last year of the lease. At the contractual expiry of the lease, the woman intends to reconstruct the building, converting it into flats. The reconstruction can't reasonably be carried out without obtaining possession of the building. She's obtained the necessary planning permission for the works. Right, looks like she satisfies the test for the reconstruction ground. The woman has just received from the tenant a notice under section 26 of the LTA requesting a new lease. So tenant wants a new lease, woman wants to oppose it. She seeks legal advice about whether she can oppose the tenant's request on the ground that she intends to reconstruct. Right, what advice should the solicitor give about whether the woman can oppose the tenant's request for the new lease on this ground? A, woman can rely on this mandatory ground and compensations payable. Right, reconstruction is a mandatory ground, so that's definitely right, and compensation is available for it. The only question is the tenant entitled to compensation? Well, the tenant does have security of tenure, so that's true because they're in occupation, we're told that. And compensation will be payable on this ground. Yeah, absolutely. It looks like A is right, but let's just see if we can rule out the rest. B, the first bit's the same as A, but compensation is not payable, so that's clearly wrong. C, the woman may rely on this discretionary ground. Well, it's not, it's mandatory, so we can rule that out. D, the woman can't rely on this ground. Well, she can rely on this ground, so we can rule that out. E, the woman can't rely on this ground. Well, we can rule that out as well then. Okay, so yeah, it looks like A is the right answer. How do we do?
SQETV.
So, did I get the right answer for this question? Drum roll, please. Yes, I did. Of course I did. It's my practice area. The correct answer was A, that the woman can rely on this ground. It is mandatory and it is compensatory. Now, what we're going to do in the next few minutes is to give you a more deeper analysis of my thought process, my internal monologue, so you can see how I arrived at the correct answer and why I rejected B, C, D, and E. So let's go through the question and give you my thought process. So 3 years ago, a woman bought the freehold of a building which is subject to a lease of the whole building protected by the Landlord and Tenants Act 1954. So 2 points coming out of that paragraph. First of all, this is clearly a security of tenure question. It mentions the 1954 Act. I'd be very surprised if it wasn't. Very popular topic for examiners testing property law and practice throughout the whole of the LPC. When I was a property module leader, it was one of the favourite topics that examiners would have when setting the examination paper, and I think it's no different under the SQE regime either. So that's 1 point coming out of the first paragraph. The other point that might be relevant is that the landlord only bought the landlord's interest in the freehold 3 years ago, but we'll just park that fact for now. We don't know whether that's going to be relevant. Second paragraph says the tenant runs a recruitment business from the building. So the tenant's in occupation, and I'm immediately thinking to myself, right, we're told the tenant's got security of tenure, but what's important is that if the tenant's applying for a new lease, they need to still be in occupation, which clearly they are. The second sentence of the second paragraph, the term of the lease is for 12 years and there are 10 months of this term remaining. So for notices to be served under the Act, either by either party, the landlord or the tenant, you need to be in the last year of the lease, or have 1 year or less left, or have had the whole of the lease expire and be holding over under the lease. And in the third paragraph it says, at the contractual expiry date, the woman intends to reconstruct the building, converting it into flats. So I'm thinking, okay, landlord, once the premises back, is going to oppose any application by the tenant for a new lease and has one of the grounds potentially available, which is reconstruction. Don't always get home on that ground because there is a little test to prove. First part of the test is, well, does the landlord intend to do reconstruction? Tick, we've got that. Second part of the test is the actual reconstruction works will need occupation of the premises of the tenant. in order to be able to rely upon the ground. In other words, you couldn't just do the works around the tenants and let the tenant remain in occupation. But we're told that clearly isn't the case, so the second part of the test is satisfied here. And the final part is that the landlord must have a firm and settled intention to carry out the reconstruction works. And here we're told that the landlord has planning permission, and that will be shown to the court in a contested application and would demonstrate the intention and firm and settled intention of the landlord to carry out the work. So looks like we satisfy the test, which I summarised in my head very quickly as I was going through the question. And here we go. The woman's just received from the tenant a notice under section 26 requesting a new lease. So yep, as expected, as we're going through the fact pattern, tenants asked for a new lease, and we now have got a situation where we think the landlord might be able to oppose, probably can oppose the tenant's request. Well, the last part of the scenario said the woman seeks legal advice about whether she can oppose the tenant's request on the ground she intends to reconstruct the building. So no great surprise there then. So the question we've been asked is, what advice should the solicitor give about whether the woman can oppose the tenant's request for a new lease on this ground? So option A, which we said was the right answer, says a woman can rely on this mandatory ground and compensation is payable. And the reason why she can rely on this ground is, first of all, the tenant's got security of tenure. Secondly, the tenant is still in occupation. They have a lease, so they satisfy the test to be able to apply for a new lease. But also, the woman satisfies all of the test, as we've just said, for opposing the lease on grounds of her wanting to reconstruct the premises. So she can rely upon that ground. It is a mandatory ground. It's important that you remember which grounds are mandatory and which ones are not. And then the last part of the question, can you see there's three different parts here? The last part of the answer for part A says compensation is payable. And I remember that compensation is payable, not for all mandatory grounds, but certainly for reconstruction. So you can see there are three different parts of this. Can the woman rely on the ground? Yes, she can. Is it mandatory or discretionary? It's mandatory. And finally, is it compensatory or not? So the three different parts of this question we had to get right in order to settle at A being the correct answer, which it is. So let's explain now why B, C, D and E are all wrong. I'll do it in a bit more detail than I did when I was rushing through the question against the clock. So the first part of B, you can see, is identical to A. The woman can rely upon the mandatory ground, so that's all right. But it then says compensation is not payable. So clearly that's completely the opposite for the last part of A. That's clearly wrong. What about C then? The woman may rely upon this discretionary ground, and if the woman successfully opposes the tenant's request for a new lease on this ground, compensation will be payable. Well, compensation is payable, but the woman can rely on the ground, but it's not discretionary, it's mandatory. So actually it's that part of the answer that clearly is wrong, and therefore we can reject C. D, the woman can't rely upon this ground as she's not yet owned her interest for sufficiently long. Now, interestingly, well, to say she can't rely on this ground is wrong, because she can do. It's a mandatory ground and she's proved all the parts she needs to. The ownership criteria in terms of how long she's owned it for is only relevant if you're claiming to oppose the tenant's request for a new lease on the ground of wanting possession yourself as a landlord. She doesn't want possession of herself longer term. She wants to just carry out the reconstruction. So we can rule out D. And finally, E, the woman can't rely on the ground as the lease is less than 14 years in duration. Interestingly, the 14-year rule is about the amount of compensation. So if you've a tenant had the lease granted to you for more than 14 years and been in occupation for more than 14 years, then you will be entitled to higher compensation than if you'd owned it for less than 14 years. So if the tenant's been in occupation for less than 14 years, there's lower compensation payable. But that's got nothing to do with whether or not the woman can rely upon the ground. The woman can rely upon the ground because we've proved the facts that she has a firm and settled intention to carry out the reconstruction, in respect of which she needs possession of the whole of the premises. So clearly A was the single best answer, but hopefully you can see how I've done a thorough analysis and ruled answers in or out, as the case may be.
SQETV.
Now, as we always do when we finish one of these videos, we give you a summary of the key law that was covered, and also we give you to go away a few what-if scenarios to get you to work out, well, how would your answer have differed had the scenario been slightly different. So, what were the key topics here? Well, clearly it was security of tenure. Not the whole of the topic, of course, but certain parts of it, and in particular, it related to the landlord's grounds for termination in a situation where the landlord wants to bring the lease to an end, and very often the tenant will want to seek a renewal of the lease. And just to remind you, the landlord's grounds for termination, you can find them in section 30 subsection 1 of the Landlord and Tenants Act 1954. You don't need to learn that section number for the exam, I'm certain of it, but you do need to be familiar with its contents, in particular to know whether or not the grounds that are listed are mandatory or discretionary. And by being mandatory, it means that the court, if it accepts that the landlord has proven that the ground exists, then the court has to refuse the tenant's request for a new lease. Equally, if it's a discretionary ground, the court doesn't have to refuse the tenant's application. The court has a discretion in those circumstances. And also what the question covered was whether or not a ground is compensatory or not, because just because a ground is mandatory doesn't mean to say that compensation is payable if the landlord successfully proves it. One case and example which wasn't relevant on the facts of this case would be section 31 subsection D, which is the ground where the landlord proves that suitable alternative accommodation has been offered by the landlord to the tenant. If the court accepts that, it's a mandatory ground, the tenant doesn't get the premises back, but the landlord has to give the suitable alternative accommodation, but does not have to pay compensation. And one other issue here was the timing issue. Interestingly, nothing turned on it on the facts of this question, but you were told that the landlord bought the premises 3 years ago. That's the freehold reversion of the premises 3 years ago. Now, had the landlord been going for rejecting the tenant's request on grounds of wanting to occupy the premises themselves, there's a 5-year qualification period which she would not have satisfied. So it might have been something that put people off, but wasn't relevant on the facts here. But obviously in the what if scenarios we're about to suggest, well, what if the landlord did actually seek possession on grounds of occupation themselves? Then your answer might be slightly different. So looking at those what if scenarios, let's just go through them now. So what if, and just to remind you, these what if scenarios are here for you to go away and have a look at. We won't give you the answers, but if you thoroughly tested yourself and thoroughly understood the topic, you should be able to work out what the distinguishing features of each of these scenarios are. So what if the ground for termination was that the landlord wanted possession for its own occupation? So that might be something that's relevant here from the point I just mentioned. Secondly, what if the landlord claimed it wanted to reconstruct but didn't really have any intention to do so? Thirdly, what if the landlord's ground was for persistent lateness in payment of the rent? How would that have changed your answer? And finally, what if the tenant had previously sublet to the subtenant who was still in occupation with the landlord's consent? How would that have changed your answer? Go away and have a think about those. If you know and can work out what the subtle difference in the fact pattern means in terms of your conclusion, then you're on the right pathway. Well, I hope you enjoyed this video. If you did, please don't hesitate to like and subscribe to the channel. Leave a comment in the chat if you liked it, in particular if you want us to cover any other of the questions in the SRA's question bank. We will do that if you request. Just tell us the question number in the bank, whether it's on paper FLK1 or FLK2, and we'll do the rest. So please do subscribe to the channel. If you tap that notification bell, you'll find out as soon as our new videos drop. And as we always do, when we finish a YouTube video on SQETV, we say it's now time for the jingle.
If you wanna be